All right. What we have here is an actual lawsuit, okay? Of course, we took it and modified it to, redact it, the customary thing that governments do. And so you can see it's very similar to the other form that I showed you. The difference is on this one, I'm going to show you some of the content. But anyway, you have the plaintiff's name, contact information in the upper left-hand corner. And then you have the space on the right is always blank. And then you have the name of the court. Now, the name of the court, the numbers don't show here, but if this were double spaced, the name of the court would go on line 8, line number 8. And then below that, you have the name of the parties. So you have, I'm a victim is the plaintiff, or counterclaimant, whatever. And he's suing these people. So you got U.S. Bank, he's suing the Superior Court. Understand that the 11th Amendment, the purpose of the 11th Amendment is to protect the treasury of the state. You cannot sue the state for money, okay? The exception to that is if the government is engaged in commerce, then they lose their sovereign protection because they're just like any other corporation, okay? So, but anyway, the Superior Court, which was an inferior court, was apparently misbehaving, and so we put the name of the Superior Court. So it's called the Superior Court of California. That's the name of the court. But then you narrow it down to which case you're dealing with. County of Los Angeles and U.S. Bank versus I'm a victim and a case number. Okay? And then there's 3 other defendants. You're Baden, another disgrace, and some poacher. Okay? Now, on the right-hand side, you have the case number. You actually put it in, whatever it is. Now, you don't know when you make the case, when you put it together, so you'll know at the time you file it. And then you handwrite the case number on the copies that you're going to serve. So anyway, this is an action, and right there, that's a hint. That's common law case. A complaint is equity, and a common law action is called an action. And this is not strict. This is just generally how it's done. If you call this a complaint, that's okay too. Okay? And what is this action about in a word? In the common law, there are 11 causes of action. Okay? One cause of action means reason for suing. Okay? So one category is called account. When you sue for account, what it is you're suing for an accounting to know what transactions took place. You just want to look at the data. So that's what suing for account is. And this is very handy because you'll see, for example, in a will, somebody will make a will, and then in the will there will be a provision that none of the heirs may challenge it, and if they do challenge the will, then they are excluded from the will. So that helps to keep fighting from happening between the heirs. Yeah. Okay, but if you sue for action, you're not challenging the will. You just want to look at it. Sometimes somebody who has possession of the will won't let anybody else see it. and they'll do that with the cooperation of their own attorney. So this is how you get around that. You say, because we're not challenging the validity of the will. What we're challenging actually is the veracity of the will. Meaning, I didn't quite say that right. You're challenging the performance that's being done. Is the person following the instructions in the will? And you do this by looking at the accounting. Where did the money go? You're not saying it went the wrong place, you're just saying where it goes. But of course, if the person who's administering the will is dishonest and he's putting money in his own pocket, that's still not a challenge to the will, that's actually dishonesty. Okay? So the category action, you're suing for action, is a great tool for doing, and in one sense, what's called discovery. But it's a little higher category. It's not just discovery. We want to see everything. We're also suing for ejectment. Apparently somebody got thrown off the property. Okay? Then you have suing for case. Now, in the 11 categories of suing, causes of action, one of them is called trespass. Trespass means that an injury was caused with force or the threat of force. Okay, that's what trespass is. There's also what's called trespass on the case. Trespass on the case is really just like trespass, except for one thing. There's no force involved. No implied force, but something's wrong. But, for example, let's say that a con artist beat you out of some money. He didn't threaten you, he just suckered you. Okay? So that would be a trespass on the case. When you see just the word case by itself, that's the same thing as trespass on the case. Okay? So here we have three actions that are called case. Okay? One of them is for a declaratory opinion. When you have a contention between two parties, you can sue for a declaratory judgment. In other words, no injuries have occurred yet, but you have a difference of opinion which could end up in a lawsuit later. But the two parties, what you want to do is you want to decide what's the right thing to do to begin with before you actually follow through on it. Maybe you have a contract with somebody and no work has been done yet. You haven't started. And already there's a disagreement as to what should be done, how to interpret the contract. So you sue for declaratory judgment and the court will tell you how to interpret the contract. Barratry and champerty. Barratry is when somebody goes around encouraging lawsuits, frivolous lawsuits, okay? Champerty is when you're championing a lawsuit, okay? So somebody, you're right in there pushing for a lawsuit, you know, you're supporting it, but you're not a party. So we're suing them for champerty. And then the unwilling co-plaintiff. There's a case that I'm watching now where this one person had something going with a second person. It involved selling property. And what happened was the escrow company pulled a fast one of some kind. And both the plaintiff and the defendant were injured by that one action. The plaintiff is suing because the defendant refuses to help out. Okay? Even though the defendant got hurt by the same company, he's not doing anything about it. So we're including him in as an unwilling co-plaintiff. We're forcing him to work with you in suing the company. Okay? You run into situations like that, where, no, I don't want to do anything, you know. No, you have to do it. There's too much involved here. You can't just back out. You can't leave me hanging, and I need you. Okay? So that's what we have here, unwilling co-plaintiff. And this is a pretty good-sized case. Well, it is 13 pages, apparently, or 14. So we have a table of contents. So the first thing we talk about is jurisdiction. Then we present the law of the case. Then we make an overview statement of the case. And then we deal with the causes of action, the reasons for suing. And it goes through the same thing that was listed up above is listed here. Then you have the prayer. The prayer, that's your way of letting the court know what it is that you want the court to decide. That's all the prayer is. You can pray to God, or you can pray to the court. If you're praying to the court, that's secular. It's not a religious event. It's just all a prayer means is you're asking. Okay? And there's two ways of asking. You can request or you can demand. A request is used when you're asking for a favor. You want the court to be a good guy, helpful, okay? A demand is when something's owed to you by right. At least in your opinion, it's owed to you. It's your right to be compensated for your broken bone or whatever. So that's the difference between a request and a demand. And then finally you verify the contents. Verification, all that means is that you've looked over the lawsuit, you're familiar with its contents, and so and this is like an affidavit, same thing. Okay, so let's kind of go down here a little bit and see if there's anything interesting. Okay, comes now, I'm a victim, a people of California and a people of the United States, and in this we're covering both bases in this case. Okay, and in this court of record, hereinafter constitutional court, complains of the following defendants. Now notice this. We said the people, we said this court of record, but then we gave it a new name. We called it a constitutional court. So later on in the lawsuit, every time you refer to the constitutional court, you're referring to this court of record. Sometimes, like, you remember I said you don't make judgments for the judge or for the court. You don't decide something. It's up to the court and the court's tribunal to decide. So what you do is, how should I say this? What you do is you make your comparisons of whether something appears to be a conflict or appears to be a misrepresentation. You're not saying it is, because that's the business of the court, not your business. Okay? But also, you can be a little bit, how should I say, innovative. For example, in one lawsuit, we said that the police had arrested the person. Well, was that person arrested or not? I say, don't say you were arrested. Okay? I would say that you're carried away against your will. Those are facts.
Kidnapped?
Kidnapped is a conclusion.
Okay.
You can't say kidnapped because that's a conclusion. Were you kidnapped or were you rescued? That remains only the court can decide that. But you present all the facts, and you can say that your impression was you were being kidnapped. Sure. But here's a cute little trick. You say, let's say John Doe, we say this, there's this policeman who had done this thing, and policeman's name is John Doe, hereinafter identified as kidnapper. And you spell kidnapper with a capital K, now that's his name. You didn't say he was a kidnapper, but it's kind of a nice sounding name. So you can be innovative to some degree. You have to be genuine in what you're doing. But, you know, if it looks like it was a kidnapper, you're not saying he was. No. That's just for purposes of brevity. I'm going to call him kidnapper rather than write out his full name over and over again. Okay? Always spelled with a capital K, which makes it a proper name.
Did you say not said kidnapper?
Huh? No. I didn't say he was a kidnapper. No way. I just said that's his name. It's a name by which John, that is an alias. You can put in an alias, which I said here. U.S. Bank National Association, hereinafter U.S. Bank. Okay? Superior Court of California, County of Los Angeles. I put in the whole name of that court. U.S. Bank versus I'm a victim. Here, and then I say down here, hereinafter inferior court, again spelled with caps, making it a proper name. And then I use the actual names of the remaining defendants. Another disgrace, you're a bad one, and some poacher. Okay? At all times, material to this action, each defendant is resident or does business in the County of Los Angeles, California. That just shows that the court can have jurisdiction based on where this person roams around. All acts necessary or precedent to the bringing of this action occurred or accrued in the County of Los Angeles, California. I'm a victim as the true and rightful owner of record, and entitled to possession of the domicile commonly known as, and you got this, 9876, this the place. Right. Okay. And we put down the property description, okay, according to the official assessor's record. And we put the address here, didn't we? Yeah, commonly known as. So you have the recorded description of the property, and then you have the common address of the post office address, like. The grant deed exhibit 2, oh, I know what I did there. The grant deed exhibit 2 is incorporated by reference as though fully stated herein. So we had a grant deed, and we could make that grant deed as one of the pages, or we could have it as an exhibit and incorporate by reference. So that saves a lot of rewriting, okay? Your exhibit can be fully described in the lawsuit, or you could have it as an exhibit and simply incorporate it. Why would we do that? The reason we do this is because of the rules, the court rules. The court rules say that you're limited to 15 pages, okay? The rules also say that you have to have double-spaced typing. Well, you could overrun those 15 pages pretty easily. So what you do is you take some of these things and set them outside the lawsuit or outside your complaint form. You have it as an exhibit. There are no rules relating to exhibits. So we say right here, up above, where is it? I said the law of the case. Did I say that here somewhere? I thought. Well, anyway, I don't see it now. But the idea is that the law of the case could be 20 pages, okay? All the different laws that the sovereign is decreeing. So that violates the basic rule for a complaint. So what I do is I put in this little paragraph and I say the law of the case, exhibit number X, is incorporated by reference as though fully stated herein. Now it's in the case without being in the case. All right. You attach it as an exhibit when you assemble it all together. The following exhibits are true and correct copies of originals as received by plaintiff. The grant deed, apparently the case U.S. Bank versus I'm a victim, the MLS record of some poacher's activities, and 3 letters to some poacher. And so you go through it. Now here's the law of the case. This is what I was talking about. Exhibit 1, the law of the case is included by reference as though fully stated herein. I don't know how big that law of the case is, but it's going to take a few pages. Plaintiff alleges that under the unlawful rubric of a foreclosure sale followed by an unlawful detainer action without any credible showing of jurisdiction, all defendants unlawfully ejected plaintiff from his domicile. On information and belief. Information and belief is, by the way, another often used phrase. You don't have the facts. You don't know for sure. So you say, well, on information that I have and on the belief that I have, I allege this is what happened. And somewhere along in the processing of the case, you will have to prove it, but at least you've got a running start at it. So that's what we say on information and belief, we such and such. So, further on information and belief, plaintiff alleges that defendant, some poacher, after plaintiff's repeated invitation, is an unwilling co-plaintiff. So some poacher himself is a victim. Okay? And you're saying, and after plaintiff's repeated invitation is an unwilling co-plaintiff, and as such, by his silence, is named as a defendant and co-conspirator with the remaining defendants. Exhibit 4 and 5 are in support of this allegation. And now, in each of the following causes of action, as though fully stated therein, are included paragraphs 1 through 14. Okay, so all this stuff up above, from the first paragraph, right there, all the way through to the 14th paragraph, all of that in each cause of action is included. So that way you don't have to be repetitious and put the same stuff in over and over again. So the cause of action, each cause of action is like a separate mini lawsuit within the lawsuit. Okay? So we go through the various things, whatever the complaint is, and finally, after all these causes of action, let's see, what do we do up here? Oh, this is a footnote. Okay? You can have footnotes. Another footnote. Okay, and the next thing will be, okay, the prayer. For those causes of action, therefore, plaintiff brings his suit. Wherefore, plaintiff requests relief and judgment against defendants as demanded in each cause of action. That the court enter a declaratory judgment that defendants have acted arbitrarily and capriciously, have abused their discretion, and have acted not in accordance with law, but under color of law. That the court enter a declaratory judgment that defendants' actions were in excess of statutory jurisdiction, authority, and short of statutory right. That the court permanently enjoin defendants from interfering in any way with plaintiff's local or lawful right to his peaceful domicile. Okay. So goes the various causes of action. Okay. And here's where you're asking what you want the court to do. You're saying that the court enter declaratory judgments in various things, and you want that the records of inferior court are impeached for want of jurisdiction, for collusion among the defendants, and for fraud by the parties with respect to the proceedings. That the court grant plaintiff his attorney's fees. Now, that's an interesting kind of thing. If you do not demand attorney's fees, then you won't get them. See, these courts are, by tradition, they're kind of organized on the basis that you're part of the nobility and you have unlimited funds. Okay? So, this is a way of protecting your own funds. You want the other side to pay if they lose. Ask for that the court enter a declaratory judgment that the records of inferior court are impeached for want of jurisdiction, for collusion among the defendants, and or for fraud by the parties with respect to the proceedings. That the court grant plaintiff his attorney's fees, that the court grant plaintiff such other and further relief as the court deems proper. For interest as allowed by law, and for costs of suit therein. Okay. Now we have, after the prayer, we have the verification. So note what it says. I'm a victim. I am the plaintiff in this case. I have read and understood and understand the foregoing writing. I have personal knowledge of the foregoing facts and am competent to testify as to the truth of these facts if called as a witness. I declare under penalty of perjury under the laws of the United States that the foregoing facts are true and correct. So there you are. There's your whole lawsuit. Any questions?
Is there somebody that you could give to look it over and make sure all your T's?
Yeah, you review it.
Is there somebody you can get to review it before you turn it in?
Of course. You always review it if you have the time.
No, somebody else that knows more.
Oh, but not that. There's more.
Is there like a legal aid kind of thing? Or?
No, there's more in the sense that they have other papers to follow, to file. One of the papers you're going to have to file is the cover sheet, civil cover sheet it's called. Even though this is not a civil case, it's a common law case, this is where it's going to be processed in the civil system. So this is just a little example, okay? Got a writ, got Scottish. Okay. I need to explain what it means to file a paper. Do you know what the word file means? Anybody know what the word file means? The actual original filing?
Yes, you told us yesterday. I forgot. Sorry, Dan.
It means wire.
Means?
Wire.
Wire?
Yeah,
Oh, yeah, because they used to hang things from wire.
exactly. When you gave something to the clerk put it in a bag and hung it on the wire in the closet.
Right, that's
Fire.
Yeah. So, different courts they try different techniques. If they don't want to file a paper, but they don't want to give it back to you either, they will say it was, what is the word? Lodged is one of the words they say. You give the paper to them, they say it's lodged. Or they will say, there's another term. All right, can't forget, remember that.
Received?
No, not redeemed, definitely.
Received.
No,
That's what they say.
well, they can be received as well, that's true. But there's another word too. Sorry, I can't remember it, but I will, I guess, along the line. But the thing is that that's kind of how the equity court is working. If they really don't want to file it, they'll just say, well, it was lodged. Okay? However, lodged, Lodged. He gave it to him. That's what I mean.
But they have to stamp they
Yeah, if they lodged it, they have to stamp it lodged, sure. The problem is that legally speaking, that's not valid. Okay? The file, you're giving it to them is valid. But what happens is that the courts have said in the past, when there were disputes about the status of a paper, if you give it to the court, to the clerk, and that clerk takes it, it's filed no matter what. Okay? So I've done that a lot where I get a reluctant clerk and I say, well, just stamp it lodged or received or whatever they do. Okay?
Acknowledge that the clerk acknowledge.
I've never seen it stamped and acknowledged.
Why would they not file it?
Maybe they mistakenly think something's wrong. Okay? Or it's a paper, we've never seen this kind of a paper before. So maybe have to look at it later, but they'll mark it they won't mark it filed. No. They'll say it's lodged or received. And I think there's another term.
And you can't put that on demand thing that you said earlier?
You can't put it on what?
That phrase that you said, take it straight to the judge and let him decide?
Well, no, you could, it's okay. Is this the same one? Well, we have quite a wind outside, along with the rain. Where? Oh, the joke file? Well, yes, I did want to show you something. Let's see. Actually, yeah, there are various jokes there, but I have video as well. Let's see. Oh, here it is. Video.
Jokes and video.
Answering. Let's see. We're at
93, you don't text me.
They did it. They were with it.
Okay, you got to watch this one closely. This is The Luckiest Man Alive. Okay, it's called.
I'm not sure how we're gonna do the audio, but just test it out, and just so.
Sure. Well, this one's not, audio's not, no
That
audio.
mic may pick it up from your laptop.
Yeah, you don't need the audio. But you got to watch it closely. Somebody had his camera on. Uh-oh.
Oh.
Yeah.
Went out the front window.
And
he's still standing?
Wait, what happened?
There it's in slow motion.
Why did he turn?
No, he lost control.
Oh, there's another car coming over.
Something happened,
Yeah, he flew off his window. He was lucky he had gone to the,
and dropped his blanket.
yeah.
So that
Is he the
idiot turned
passenger?
in front of him.
Well, like Charlie Brown had his blanket for security. Yeah,
He was fast, he lost control.
something.
That idiot turned in front of him.
Oh, okay.
He turned in front of him, he was trying to avoid hitting him, and
Go ahead.
do it again.
You want to do it again?
3 times the charge.
So this is the lawsuit, I guess.
Oh, yeah, like I said. Oh.
Okay. There's everybody's normal there.
Oh, I don't know what this is.
That's
Oh,
the
this-
Hindenburg.
Oh, yeah, that's the Hindenburg. There's a guy running on the top of it.
Was that really
No,
the
that
case?
ain't.
Yeah,
You running on top of it?
yeah. There we go.
And he's the one who blew it up.
Sure.
Whoa.
I heard that.
Oh, that's a funny one.
Conspiracy. Because it was supposed to be suspended and the airplane.
So, this is, I want to show you 1,000 years of European history.
How long would that be?
Very short, 10 minutes or less. But I want you to notice how non-permanent countries are.
Interesting. They're just temporary.
Assuming I can get it started. Yeah, here we go. Got the year down at the bottom there.
Well, oh wow, look at that.
Wow.
Man. They were all, well, that didn't happen until late 1800s, right?
This is 1300s.
Look at that. King Arthur and his knights are still cantering around.
And Hungary's been there for a while. Empire. Where's our
The
meeting?
Ottomans, yeah, where's the Armenians?
It didn't exist as a country.
Russia's
They got-
rolling over into
There goes Columbus.
Oh yeah, Columbus. 1492.
Russia, whoa, look at Russia.
Boy, it really got divided.
Spain.
Where's Genghis Khan?
Poland.
Wow,
Wow, look at Russia now.
Yeah.
wow, look at it, just keeps.
You know, those little kingdoms there.
And the
Yeah, look at
Ottomans.
it, yeah, that was over in Germany, right?
Yeah, the Ottomans.
Yeah. And that's what Bismarck united them all, right? And then Germany became powerful. And then they had to take them down in World War One.
I didn't realize Poland was that big. Uh-oh. That Russia is really.
Wow, look at Russia.
Whoa.
Oh my God.
The Tsar. Romanov. So the Lenin and Trotsky took him out.
Cheese, yeah, Russian cheese.
Yeah, that's why the big gifts are over the Hessians. Wow, look at that. Man.
Oh my God.
So yeah, Russia lasted about, what, 200 years, right?
Italy, look at
Oh, there's Germany. Yeah, late 1800s, right? There's- Now that's why they had that World War I. Revisit them.
Oh,
Oh, that was during World War II, they did.
World War III days now.
Oh, we're in there right now.
he's supposed to be in the martial law.
Well, they-
Oh, started over.
that's what COVID was.
Yeah,
That's interesting.
They just called it something else.
yeah.
That was the martial law right there.
So anyway, I thought you might be interested in that.
That was interesting.
Um,
Very.
well, I guess that's enough of the break. Got to get back to business here. So, okay, yeah, there it is. So you can download the entire rules of court. That's what I have here.
Okay, that's on the website.
Well,
That's from.
you can get it on the internet. You know, I don't have those on my website.
Google Rules of Court, and you'll get it.
Mm-hmm. Right. This is the various amendments we got on the computer. Okay, I guess that's.
I'm not talking about the Trojans here.
Well, I have to admit, I'm running out of steam.
Oh,
I think the weather,
Well, no, I'm just tired, you know.
exactly.
Put a lot of energy
you
on
bet,
it.
you,
Yeah.
Yeah.
So, how about if we go into entertainment mode?
Yeah.
Do you like that? I got some stuff that's kind of nice. All I have to do is find it.
Who are you? You've got hard labor.
Well, we've got. Okay. Do you like car? Here's a car salesman. No, not that one. Here it is. Well, here's a crazy grandma. You all know what Polaroid cameras are? Okay. So what she does, she replaces the film with a picture that's already taken. Okay?
Okay.
And now you'll see how she uses that. Let's see, here we go again.
Oh, yeah.
Yeah. I think, yes, she said there's somebody in the house, so she helped her. This be great.
Let's her in on the trick. This one is an ad, but it's really cute.
The poor goldfish knows.
I don't think we're getting sound out of this, are we?
No.
Uh,
Oh my God, we don't need sound.
well, what the goldfish does is it barks at the cat. Scare.
Watching the dog.
Learn another language. The goldfish learned another language. Dog speak. Or cat speak. Anyway, so that was that one. Here's an instant replay.
That's part of that.
Yeah. Huh.
That was good. But you just watch it, okay? That's good.
We can't get sound out of this, huh?
Well, it might be going through the HDMI or,
Yeah.
and then your projector doesn't have the sound, doesn't have a speaker, does it? Your projector?
Yes, it does have, but I don't think it'll work because that's a VGA connection.
Oh, yeah, VGA doesn't carry sound, yeah.
Yeah.
Well,
What?
let's see. What do you think?
What if you go there? Click on that volume thing.
Oh. Yeah, there it is. Might be the reason.
And then click up on that.
I got 100%. Here?
Yeah, click there.
Oh, you're
Try
talking.
that one.
Oh, try the other
Maybe that'll
speaker.
work.
Okay, good idea. Okay, we'll try this. Oh, here's an answering machine message. It's audio, but let's see if it works. Okay, can't hear that. He's saying it's an answering machine message, and he's saying this is so and so. I'm not answering the phone because I'm avoiding someone. Please leave a message, and if I don't return the call, it's you. So.
Yeah, it's normally 100, but I'll do 80 if you can, and I'll send you all the files digitally right away. And then what I'll do, I'll include about 40 gigs of files that I have that before it can pass, but I'll include all of this on there, so you'll have everything that's available. Yeah. This leaves me, eventually mailing address and or your flash drive, definitely, email or cell phone something, send you the, files. Yeah.
No,
Let me go on Zoom, I'll see you, we're gonna deal with it, as long as you leave me, an address, eventually, but right away, an email, so,
It's okay.
yeah. Mine's on the website, look it up.
I'll call you first. Arjun, we're not on, right? We're not on. We're not on.
We're still recording, we have about 15 people at home.
Yeah, I've kind of lost it. I run out of energy, which I apologize.
That's all right.
But
Anyway, one person asked they thought this was interesting, it was English speed, and then he said, what's the website? So,
yeah, the website, yeah,
1215.org. So.
yeah, 1215.org is
Yeah.
the website.
Yeah.
1215.org. And so,
So, okay,
See if there's any final.
I have cash in there for the people. So when you check how much it is cash, you
Hey, Bill, there's one,
So,
there's gonna be one question that the viewer has for you this minute.
okay, I'll try to answer it sensibly. What is it? What's the question?
Okay. Okay. CyberGus says, when you sue in common law, you open a court of record, and a court of record keeps record of the proceeding. Who does that? Because they usually only write minutes, but not the transcripts.
You don't need the transcript. The docket sheet, which they sometimes call the record of action or report of action, the docket sheet has the information. For example, it shows what papers got filed. It shows what decisions were made by the judge. Okay? And that's all you need. If it's a court of record, doesn't matter what decision the judge made, it's wrong. Because he's not allowed to make any decisions in a court of record, any decisions that involve discretion. Okay? He has a ministerial function in the same sense that the clerk has a ministerial function. Time out for wood chopping. Okay, we're feeding we have an old potbelly stove to heat up the place, and he's cutting some more wood.
like all times, it's like the forefathers.
Okay.
Bill, one final question from Plead.
Yeah.
Earlier you talked about judicial cognizance. How does one use this? Is it a writ, a demand, or if you have already explained this, then you'll catch it on the replay?
Well, the law of the case is the law of the sovereign. And with the judicial cognizance, what you're saying is that whatever decision the court makes, that decision must conform to the laws, and the judicial cognizance is essentially the order from the sovereign saying that you cannot have a decision that would be contrary to the law of the case. That's what it's all about, is you're making sure. And it does refer to judges, but it turns out that in a court of record, we're not going to let the judge make any decisions anyway. But what you're doing then is you're kind of setting a standard, because whatever decision you make will be in conformance as well. I hope that answers the question.
We had 18 people hung in there on the stream, so I guess we'll say goodbye and thank everybody for tuning in and everybody present here. That's it, right, Bill?
Well, unless there's somebody wants another question, I'll do what I can to answer it at this point.
Everybody okay? You don't hear anything. Let's give Bill a hand.
Thank you. Appreciate that. It's my hope that you do benefit from all this. So
Thank you, Bill. Thank you so much
you're welcome.
to do this, to come out in this weather and to, put up with the.
Wait, hold on. This is the West Coast. What we call weather is nothing on the East Coast. We don't have weather here according to the East Coast.
Yes. My daughter is calling me, I'm worried, I'm panicking, but they're saying there's flash flooding, this is storm, she's like, we come into, are you okay? I'm like, it's okay, stop,
Let's thank Ann.
I'll make a special arrangement.
let's,
Yeah, don't worry. I'll make a special arrangement. Thank you.
No.
Appreciate it.
Alan, thank you. Because of Alan, we were able to do this. So thank you so much. It was teamwork then.
Let us see that potbelly stove.
Oh, yes. Here you go.
There it is. All right.
There's the potbelly stove.
Okay. Alan calls it a barn, so.
Yes, he calls this the barn. Yeah. No, we are fortunate, we didn't have to pay a lot of, big money to go somewhere where it's not convenient as well, they have their restrictions. So here, there's no restrictions, it's great. Yeah. So, thank you, Alan. Thank you, Dennis, for doing this as well. Bill and everyone. Thank you guys for coming. Arjun, Jamela, and the rest have already left, but yes.
A lot of people left.
Yes. Yeah. Yeah.
Your kids.
Dwayne was here, Shanti. Yeah. Who else was here? We all tired because it's raining here in Los Angeles. There's a storm, they say. There's flooding. And so it's been cold, but it's been great. Warm with the words and the company. Okay. So, bye.
Thanks, Bill. Okay. Thanks, everybody. We're going to set her down.